Hello parents, JL Casey here with Child Support Victory, and we're presenting Family Court Unfiltered. That's the podcast. So, last episode we talked about why I know my rights gets parents into trouble inside of family court. We broke down the case law, what's binding versus persuasive, why courts do not care about those sovereign citizen arguments. We broke down the 5 pillars that actually protect parents inside of family court, and quite a few other things. Y'all have to go back and check it out if you missed it, okay? So, heads up, this is my first podcast. This is my first time recording myself at all like this. So, I'm not a content guy, okay? I want to make that very clear. I'm just a guy who has some information and I really want to share it with y'all. So today we're going to try to dig a little deeper because every week I keep seeing these posts telling parents that y'all can just terminate your child support case. And technically that's true. Yes, I did it 3 times myself. But what those posts don't tell you is what termination actually means, what it doesn't erase, and why most people who try it end up worse off than they were before they even started. So I'm JL Casey. This is Family Court Unfiltered. How the system actually works, not how people think it works. This is education, not legal advice, okay? So let's try to get into the truth about terminating your child support case. Termination, y'all. I know that y'all love that word. It's the word that everyone wants to hear. All right, in the case, let's close this file. Let's just walk away scot-free. And yes, that is real. I did terminate my case 3 different times, but here's what the internet will not tell you about termination. Termination does not mean what most people think it means. It doesn't erase your arrears. It doesn't make the case just disappear. And if you file the wrong motion chasing this, you'll end up losing credibility with the judge. You can set yourself back months, maybe even years, okay? So today I am going to break down what termination actually is, what it isn't, and how to know if it even applies to your situation. So again, I am JL Casey. This is Family Court Unfiltered, how the system actually works, not how people believe it works, okay? Education, not a lawyer, this isn't legal advice, okay? All right, so why I think this topic matters, the termination content is getting massive engagement online, all right? And I think it's really what people want to hear. We got parents out here that are very desperate for hope, and termination, that just sounds like freedom, doesn't it? But most of what is shared is either incomplete, it's misleading, or I'm gonna be honest with y'all, it's just completely flat out wrong. People are making major legal decisions based on TikTok clips, okay? What parents usually get wrong is they think that termination means that the case is gonna be gone and just disappear, boom, gone. They get confused, man. They think they confuse termination with modification or forgiveness of the arrears, all right? They believe there's just some magic motion or some constitutional argument that works everywhere in every state, and they don't understand the difference between ongoing support and past due balances. So what is at stake here? Again, if filing the wrong motion is going to lose you, they're going to think you crazy in the court. They're going to like, what is this? You're going to end up wasting months, years for a situation that doesn't even apply to you. Getting hit with sanctions and contempt, frivolous filings, that hurts. And then the whole time you still got your arrears growing and growing while you're chasing the wrong solution for your problem. Parents, y'all got to lock in. So here's the part that nobody wants to talk about. Even the people giving you the void order advice online. The Supreme Court has already ruled that personal jurisdiction is a waivable right. Y'all hear me? That means even if you were never personally served the right way, or even if the court technically never had power over you from day one, you can still lose that defense forever just by participating in the case. So if you showed up and argued about the amount, if you filed a motion for modification saying, man, this is just too much, if you tried to sign a consent order, or if you signed a consent order or made payments through the system, you went up there and paid yourself, you just may have already waived your right to challenge the jurisdiction, okay? So the order might have been void when it started, but it's bulletproof now, okay? So today, we're not just going to talk about what termination is, because I'd be remiss, or I feel like I'd be doing the audience a disservice if we didn't talk about what void orders are and what the Supreme actually says, and why most people who try to attack their orders have already disqualified themselves from doing it, okay? So let's get into it, parents. Y'all know how I like to do it. I like to bring up the case law. I like to tell you what the big dog said, the Supreme Courts or the federal courts. I'm going to let y'all know what's already binding in the state system. Okay, a lot of people are trying to get y'all to work outside of the system with some magic bullet that separate yourself. Okay, that's cool and dandy. That's cool and dandy. If y'all want to go down that path and work outside the system and find some magic, some sovereign way of moving, I'm not here to tell you not to do that. I'm here to teach people how to work within the system that's already controlling your order, that's already taking your kids from you, that's already denying you of your due process. I'm teaching you how to move within that system, not outside of it, okay, parents? So if that's for you, let's lock in. Let's get into these cases. Let's get our screens pulled up because y'all know how I'm working. I'm working off a bunch of different screens. I'm pulling up case law. I'm doing this in real time. All right. So, parents, let's lock in. All right. All right, parents, let's get into this. So I try to break it down into points. I try to have like 5 or 6 points, but being that we added void on here, we'll have like another subsection for that. So let's get into point 1, of course, which is termination and what it actually means legally, okay? Termination, it ends the ongoing support obligation, okay? It does not erase your past due balance, which is called arrears. It does not mean the case is just going to disappear. The case file still remains, all right? So the order stops accruing new support. That's pretty much it. If you owe $50,000, terminating your child support does not erase the $50,000. So that pretty much is the legal principle that termination only ends future accrual support. It doesn't retroactively erase arrears. Okay, child support is a vested right of the child. All right, once it becomes due, the judge generally cannot waive it, even if your child support obligations are terminated. So I want to get into 3 legal outcomes of it before we go any further. I think you need to understand that there are 3 different legal outcomes, not just one. All right. Most people get confused with this, and that'll end up really hurting your case, which one actually applies to you. So, again, you have termination, which ends the future support accrual only. Arrears will survive this, okay? And enforcement will survive, even for those arrears. Yeah, they're arrears, but they can still enforce them. They can still make things complicated for you, okay? So, what this is usually going to apply to is that the child aged out, emancipation, the custody order changes, death, death may have taken place. God forbid, hope not. Adoption, or there's a fraternity issue. You may not be the child. You may not be the child's parent. Okay. So then you have modification, and this just changes the amount going forward. It does not erase your arrears. Okay. So if you have this is usually going to apply to you if you got a job loss, excuse me, if you're on disability now, if you're retired or incarcerated, or if there's a change in custody. All that can apply to when you would need modification. But notice, even if you're incarcerated, you still need to file for modification. That's like the Fetty Wap situation, and everybody's, oh, he came home, he's 200. Did he file a motion for modification while he was incarcerated? Did he file a motion to get the arrears audited and to see if they're accurate? What has he done? Is he just sitting around with over $200,000 in child support arrears and waiting to see what's going to happen? Dude just signed for $900 million off this. You hear me? Shout out to bro, man. So, and then we have void orders. Okay, the void order was never legally valid, and this can be attacked at any time. It doesn't matter if it's 10 years, 20 years, 30 years, 40, 50, 60, 100. If it was void, then it's void, and you can attack it at any time under some guidelines. We'll get into that. I don't want y'all to think that that's just the magic key. So, what this is usually applied to is that the court never had jurisdiction. There was no service, due process, subject matter jurisdiction wasn't solid. It's a very narrow road because you can waive these rights, and we'll get into that. So, but before we get into all that, y'all already know, let's tackle point 1. Let's get into the case law. And the first case law we got is State versus Koons, 108 NJ out of New Jersey, 508 1987. And that's State, STATE, versus KOONS, Koons, I believe. So the holding was that child support arrears survive termination of child support orders. Past due amounts are vested debts that cannot be retroactively modified, okay? So the application, this debunks the myth that terminating support erases what you owe. Arrears are a separate legal obligation. And So let's dig into the case. All right, like I said, State versus Koons. Okay, so the court was actually a New Jersey Supreme Court. Y'all know what that means, big dog. So let's get into the background. A child support obligor sought to have his arrears wiped out after his ongoing child support obligation was terminated. He argued that once the order ended, the past due amount should also be terminated. Okay, so what's the legal question here? When a child support order is terminated, does that termination also erase the arrears / past due amounts that accumulated while the order was active? What was the outcome? Okay. The New Jersey Supreme Court ruled that arrears survive termination. Past due child support is a vested debt. It becomes owed the moment it was due. Terminating the ongoing obligation doesn't retroactively erase what was already owed. The arrears remain separate enforceable debt. A separate enforceable debt. Okay, that's what arrears become. All right, so y'all need to understand that. So this is the case that kills that termination erases everything. That's a myth. Okay. Termination only stops future support from accruing. If you owe $500 a month and you terminated your child support, you owe $0 a month. Ongoing. Now, what your arrears come out to be if they have you paying $100 a month, $50 a month, that's for your arrears. Okay. So arrears are a vested debt. They became owed the moment they were due. That's the case law. Okay. So even if you get your ongoing support terminated, you still owe the back balance. You need two strategies, one for termination and one to clear out the arrears. Okay. So again, this came out of the New Jersey Supreme Court. A father got his child support terminated when the kid aged out. The kid turned 18, he went in and terminated. Again, just because your child turned 18, don't think the state just go terminate your child support if you don't go in there and file for it. All right, parents. Okay. All right. So again, the child aged out, went in there and terminated, then tried to argue the arrears should be wiped out too. The court said no, arrears are a vested debt. Termination only stops future support. If you owe 50 bands in back support, termination don't touch them 50 bands. Okay, parents? Okay. All right. So let's get into the next case. Moss versus the Superior Court, 17 Cal, CAL.4396, and the year is going to be 1998. What was the holding? All right. Rejected 13th Amendment challenges to child support enforcement. And the 13th Amendment, that's that involuntary servitude. So, how did they apply this? Courts consistently reject constitutional challenges claiming child support is slavery or involuntary servitude. So, let's get into the background of this Moss versus Superior Court. All right. A father facing child support enforcement made a constitutional challenge, arguing that forcing him to pay child support against his will constituted involuntary servitude under the 13th Amendment. Okay. All right. That's what he said. So, what happened? The father was behind on child support and facing enforcement actions. Instead of addressing the debt directly, he filed a constitutional challenge claiming the entire child support system violated the 13th Amendment's prohibition on involuntary servitude. His argument: forcing someone to work to pay money they didn't agree to is essentially slavery. All right, so what's going to be the legal question in that? Does mandatory child support enforcement violate the 13th Amendment's prohibition against involuntary servitude? The outcome, okay? The California Supreme Court flatly rejected this argument. The court held that child support is a legal obligation arising from parenthood, not involuntary servitude. Parents have a duty to support their child. Enforcement of that duty is not slavery, it's basic family law. All right. So we got to stop coming at these with these constitutional arguments, man. I'm telling you, the courts have already seen it. They've already thrown it out the window. Okay. So this is the case that kills that 13th Amendment argument. Courts have rejected this argument every time it's been raised. Every time, parents. Okay. Following this argument damages your credibility with the judge. If your strategy comes from Facebook talking about slavery, please, parents, run the other way. Go the opposite way of that Facebook group, because they're giving information off TikTok or something that they done heard and they're incorrect about it. So let's keep it going. Let's get into another case. All right, on this first point. So we got US versus, I think it's Benab. 654F.3D 753 out the 7th Circuit in 2011. So that's U.S. versus BENABE. Okay, so the holding. Sovereign citizen arguments are frivolous and courts will not entertain them. Okay, so filing sovereign citizen paperwork will get your case dismissed and damage your credibility. And I don't mean to dismiss that y'all are thinking, all right? So let's get into the background of this. A defendant facing federal charges filed documents claiming to be a sovereign citizen not subject to the court's jurisdiction. What happened? All right. Benab, I think is how you say it, filed paperwork asserting he was a sovereign citizen not subject to the federal jurisdiction. He used the language common in sovereign citizen filings, reference to maritime law, UCC codes, and claims about his straw man identity. Okay, this type of violence had been increasingly common in family courts, and it don't work. Please, family, get out of that. I was lost, but now I'm found. All right. So the legal question: do sovereign citizen arguments have any legal validity in American courts? The outcome. All right. The Seventh Circuit called sovereign citizen arguments frivolous and a waste of courts' resource. The courts warned that filing such documents can result in sanctions, contempt fines, and serious damages to the filer's legal position. Please, parents, lock in. This is coming from the Supreme Court, okay? All right. Federal appeal courts call this frivolous. That's their word. They call it frivolous, okay? UCC filings, straw man arguments, maritime law claims, none of this has been proven to work anywhere in court. Okay, it hasn't been shown to work. Not in court, not on record. And I know we have our myths about that, and I'm not here to dispute that. I'm telling you what's working in the legal system, not outside of it. All right. So filing this stuff will get you labeled as a problem. Okay. It will get you labeled as a problem litigant. He's just wasting our resources. Okay. Judges share information. The label follows you into every future hearing. All right. So, however you say this guy name, I think it's Benab. It's a federal appeals case that called sovereign citizen arguments frivolous. UCC filings, straw man arguments, claiming you're not subject to the jurisdiction. None of it works. And filing the paperwork get you labeled as a problem. Judges talk. They're going to talk to each other. This type of stuff is going to follow you. Please be aware of what you're filing, okay? So, with that being said, let's try to get into point 2. That's going to be the legal grounds that actually work for termination. So that's going to be your child aging out. That's going to be 18, 19. If they're still in high school in some states, it's going to vary, okay? And then you got child emancipation. That's going to be if they get married or they go to the military or if it's court ordered, okay? So changes in custody. The child now lives with you or y'all have some type of court order for equal custody and your ongoing support is terminated. And then you got the death of the child. That's tragic. It really is, but that is legally relevant to what termination is. Okay, so termination of parenting rights. This is rare and extreme circumstances where this may take place. Okay, so don't think just you can walk in there and waive your rights and child support is going to erase from you. Okay, or get terminated just like that. All right, understand the nuances. All right, then you got a fraternity issue. All right, or what do you call it? A disestablishment. That's more the proper word, fraternity disestablishment. And this is just proving that you're not the biological father. Okay, that's going to be another way to terminate it. And I'll be honest with you, even that's not a walk in the park. So let's get to this framework. All right. I don't want to talk about, even though we're on this legal grounds to actually terminate it, but let's get to the framework of actually what opting out is going to look like. So let's talk about this first case law. All right. You got Blessing versus Freestone. I know this is a big one in that community. It's a big one, all right? So Blessing versus Freestone, 520 US 329. That's going to be in 1997, all right? So that's Blessings versus Freestone. What's the holding? Title 4D is a complex federal state administrative scheme. States must follow it to receive funding. States have to follow this if they're going to receive some money, all right? So how do we apply this understanding? The child support system operates under federal authority, okay? You can't just opt out of it. This is federal. All right, so let's get into it. Let's get into that case law, Blessing versus Freestone. And again, this is the U.S. Supreme Court. This was coming out of Arizona, I believe. So, background. Mothers receiving child support through Arizona's Title 4D program sued the state, claiming that the state wasn't doing enough to collect the support owed to them. All right. What happened? 5 mothers in Arizona were owed child support that the state wasn't effectively collecting. They filed a federal lawsuit arguing that the Title 4D of the Social Security Act gave them a right to sue the state for failing to provide adequate services. I need y'all to understand the breakdown of this case law because I know it's a big one in certain communities, but knowing the legal question and what actually happened in case law is such a big thing. And we fail to realize that, okay? So, what is the legal question? Does Title 4D create individual rights that parents can enforce through federal lawsuits? The outcome. The Supreme Court held that the Title 4D is a complex federal state cooperative scheme. The key takeaway, this is a federal system. States must participate to receive federal funding. You cannot opt out. All right. So let's get to some of these major points in this case. All right. Child support is a federal system, not just state by state. It is federal. Every state has to be in it if they want to receive funding. States must comply with the Title 4D requirements to get these federal fundings. Okay. Every state child support agency operates under federal rules. All right. Wage garnishment, license suspension, passport denials, federal requirements. You can't opt out of a federal system. So understand what the case law is really saying. Please, parents, bless and confirm that child support operates under Title 4D, a federal framework. It's not just your state coming after you, okay? It's a federal state system. Wage garnishment, license suspension, passport denial, those are federal requirements. All right. You can't just opt out of this. All right, parents, we got to get into this. All right. So let's get into some statutes that's relevant to it as well. So let's talk about 42 USC 666A9. Yes, that's the actual statute. Okay. I ain't making this up. We ain't making this up, y'all. Go look it up. Okay. All right. So federal requirement that states have procedures for enforcement of child support through income withholding, liens, and contempt. All right. So what it does. All right. The federal statute requires every state to have specific enforcement procedures. All right. Usually it's going to be income withholding. You got liens. You even got credit reporting. So the people that think they can't report it to your credit, that is not true. It just has to be accurate. And I have something on my Instagram page relevant to how you actually properly get child support taken off of your credit report. Because to say it's not legal, that's the feds telling y'all that it is, okay? So again, they have to have requirements for enforcement procedures. That's going to be income withholding. You got liens, you got credit reporting, license suspension, passport denials for arrears, anything over 2,500, they coming after your passport, all right? And you got contempt proceedings. States must have all of these tools or they're going to lose their federal funding. Man, it's a money game. So enforcement is the same everywhere. Every state is going to have these same type of enforcements, all right? Because it's a federal law. That's why all the states align the same, okay? Then you got states don't choose these tools. They don't get to pick and choose. They are required, mandatory. All right. Passport denials are going to kick in at 2,500 in arrears. That's federal, not state law. Moving to another state does not help you. All right. Same rules apply everywhere. Don't get me wrong, there are some nuances in certain states, but the same set of the rules for enforcements are going to apply everywhere. Now, you got some nuances as far as custody and the rules of who has the authority at birth, different states for different nuances. All right. So 42 US 666, that is the number. Okay. It's why enforcement looks the same in every state. Federal law requires wage garnishment, license suspensions, passport denial. States don't get to pick and choose. Moving to another state doesn't help. The same federal requirements follow you every single state that you all 50 states, or however many they say we got now. I lose count sometimes, but last time I checked, all 50 states got to follow this, okay? Let's try to get into point 3. Florida Statute 61.14. This governs the modification and termination of support orders. So This is the requirement of substantial change in circumstances for modification. Something had to have changed from your previous order to qualify for a change under the statute. All right. All right. So then you got a couple other statutes and authority that we can get into. Not too deep because we're going to get ready to go on to the next point. But you got Florida Statute 61.14, and this governs how modification and termination is utilized in the state of Florida, or how they work with the support order. So this requires showing of a substantial change in circumstances for a modification. That's required for you to modify or change your order in the state of Florida. You have to have, in most states, just about every state, you have to show a change in circumstances, all right? And then you got Florida Statute 742.18, all right? So this is disestablishment. This is when you end up not being the father. But strict requirements and time limit for challenging paternity after acknowledgement. Florida Statute 742.18. Again, this is the one that allows a man who is not the biological father to disestablish paternity and terminate his child support obligations. All right, so I know this sounds like freedom too, but this statute has a few traps in it. Okay, parents, y'all walk through them with me. First, you need newly discovered evidence. Okay, all right. You can't just decide 10 years later, oh man, you know what? I don't think this baby mine. I want a DNA test. You do not do that. Okay, you have to show you discovered the evidence after fraternity was already established. Okay, that evidence can be the DNA test results, statements from the mother, like you got a text saying, "Oh, she ain't even mine. Yeah, that child ain't even yours," or something like that, or something that came to light after you are already on the hook. Okay, has to be after the fact. You can't already know the baby wasn't yours. Sign for the baby, say the baby mom, I'm still gonna take care of it, and then like, oh hell no, I want. All right, father. So second, you need a DNA test that excludes you as the biological father. Scientific testing has to prove you are not the dad. All right. No test, no case for this. That's mandatory. Then you got third, the child has to be under 18 when you file. Miss that window, and that was just your child. Period. He already grown now anyway, so he or she is already grown now anyway. So you got fourth, and this is where most parents end up getting destroyed. Okay. Even if the DNA test proves you are not the father, the court will deny your petition if you did certain things after finding out that the child wasn't yours. So after you find out the truth, if you did certain things, you still did. All right, so let's get into it. Let's get into the chopping block, y'all. All right. If you married the mother after learning that you wasn't the daddy, you block. If you sign a sworn statement acknowledging fraternity after you found out you wasn't the daddy, you block. If you consented to be on the birth certificate after you knew you was not this child's dad, you are blocked from getting enough child support through this route, okay? If you made a written promise to support the child after finding out you was not this child's daddy, you are blocked from getting out from child support through this route, okay? If you ignored a court or agency notice telling you, bro, come take this DNA test and find out if this child is yours. If you got notice of it and you still booked and you ended up on child support, you cannot utilize this route to get off child support. All right. If you signed a voluntary acknowledgement of fraternity, I don't want to hear it, you blocked. I don't want to hear you ain't the daddy. You signed for this child. You are blocked from this method, okay? So the statute says, shall not set aside. That means the judge has no discretion. He can't even feel bad for you and be like, dang, bro, I hate you went through that. I'm going to let you off. No, he has no discretion. You did one of those things after learning the truth, you are locked in forever. DNA don't even matter no more. If you did one of those things, it don't matter that the child don't got your DNA. That's your child now. In the eyes of the law, in the eyes of child support enforcement, I'll tell you that right now. Okay? So here's the part nobody talks about. Even if you win this establishment, even if you win this, it only stops future support. Your arrears don't disappear. Everything that accumulated before the court granted you this petition, you still owe that. This establishment is not a get out of debt free card. Parents, are y'all hearing me? Look it up, man. This is why timing really does matter, okay? This is why what you sign really does matter. Know what you're signing. This is why ignoring paperwork It is something you can destroy you. Never just ignore child support paper that's coming to you. You fight like a man. What you hiding for? Learn what you need to learn and go stand up for yourself. What are you hiding for? It would destroy you, okay? All right, parents? So let's lock in, all right? So fraternity disestablishment under 742.18. Yes, it's real, but the window to use it is narrow and the traps inside of it are everywhere. That's how they do it. So if you think you might have a disestablishment case, you might really want to go ahead and move fast on this. You need to start documenting. You need to make sure you haven't already disqualified yourself by your own actions. Do what you need to do. Lock in, parents. I'm with y'all, man. I want you to win. All right, parents. So let's get into one more, I think, on this point before we move to point 3. Like I say, the UIFSA, and that is the Uniform Interstate Family Support Act, okay? So this establishes rules for child support across state lines. The key concept is continuing exclusive jurisdiction. Again, that's CEJ. Once a state establishes a child support order, only that state can modify it, okay? Unless all parties leave. That's the only way it's going to change jurisdiction. If the mother, the dad, and the child leaves, okay? This prevents parents from moving to get a different order. They don't want you jumping around, all right? So the UIFSA prevents from foreign shopping. That's just moving to a different state to get a better deal. The states that issue your order, they're going to keep that jurisdiction over your order. If you move, the new state is just going to enforce the old state's order, all right? All 50 states follow this rule. There ain't no other state that don't follow it. They all follow this rule, all right? So this is why you can't run to another state and just start fresh. Once the state issues your order, that state is going to keep control. If you move to Texas, but your order was in Florida, Texas is just going to enforce Florida's order, okay? There's no escape hatch on that one. So we're going to try to move to point 3. Let's try to see what actually triggers termination, okay? So child reaches age of majority, 18 in most states, 19 in some. Child graduate high school, if still 18. Hate to say it, child's death, child get married, child emancipation, or by court order, successfully, fraternity disestablishment, that does not erase arrears, adoption of the child by another party. All right, what's not going to trigger a complete termination is job loss. That's going to be a modification issue, not termination. Incarceration, that's in most states, some allow modification, okay? Retirement, new children with another partner, remarriage of either parent, relocation, informal agreements between parents. This is not going to trigger a termination. That's the point of point 3. Okay, so that's what's going to trigger it. Let's talk point 4, termination versus modification. All right, so got to learn to start following the right motions here. All right, let's get into termination. And what it is, that's ending the obligation entirely. All right, what's going to trigger that? That's going to be a legal event like an age, emancipation, custody, death, and then fraternity issues. All right, and then the real things, they do not erase. And then you got modification, and that's just pretty much changing the amount of the order. And what's going to trigger that is a financial change, job loss, income disability, and then the arrears. They do not erase. All right, so we got some common mistakes. You're getting into filing termination just because you lost your job. That's not the right motion for that. Okay, so you're getting into not filing a motion to modify until you're behind, until you start getting so far behind, you're getting arrears. What y'all need to understand about modification, the moment you put that in, it's going to hold that date. Let's say it takes a year. If you put your motion to modify in on July 1st and you don't get it actually modified until July 1st of next year, from July 1st all the way back, they're going to clear it out. They're going to modify it and adjust it to that price of what it modified to. That's why the longer you wait, man, it really matters. So, like I said, here's where most parents mess up. They'll lose their job and they'll mess around and file a termination. Think that's supposed to terminate their child support. No, wrong motion. Job loss is for modification. You're asking to change the amount, not just end the obligation, okay? Termination requires a legal event. File the wrong motion, and the judge is going to think this person doesn't understand their own case. They're just lost. All right, we don't want to lose credibility with a judge because, man, this stuff it isn't rocket science, okay? So I just want to give a warning on frivolous filing where you got Fox versus Fox. I think it's the Florida case. Parents who filed frivolous motion was found frivolous and they end up being ordered to pay the other side's attorney fees. Y'all don't want to be paying the other parent's attorney because you done filed some motion. They went and hired some lawyer to fight the motion. You go lose it because it's frivolous, and you go be made to pay the other parent's attorney fees. And we touched a few pointers. So let's get into point 5, void order exception. When the order itself invalid. I need y'all to understand this is a very narrow category. Most child support orders are actually valid, okay? Most people still owe child support. This only is going to apply when the court agency never had jurisdiction, they never properly served you, and you didn't waive your rights. But we'll get into that, okay? So there's a difference between an order that's wrong and an order that's actually void. Wrong orders are still enforceable until you appeal it. A void order was never legally valid in the first place, and they can be attacked at any given time. There is no deadline on a void order. That's a fact, okay? So, but let's get into void versus voidable because these are critical distinctions, okay? A void order. What it means is the order was never legally valid. It's a legal nullity. It was void ab initio, void from the start, never a real order. You always go back and fight these. So that versus a voidable order, what that actually means is the order had errors, but it's valid until it's overturned. Okay. If you have something that's voidable, but you don't go back and overturn it, which isn't true in void orders too, then it's going to remain. And then it can also be adjusted or fixed and still be enforced. So understand this between void and voidable. And then you got a void order. This can be attacked at any time. I'm talking about years later. And then voidable orders, they can only through direct appeals, and that's within a deadline. All right, family. Voidable orders do have a deadline. Void orders, no deadline. Okay. So a void order, the enforceability to it, not entitled to enforcement or full faith and credit. Okay, if it's void, no one's entitled to enforce it. No one's entitled to the money, nothing. Okay, so if you got a voidable order, it's enforceable until successfully appealed. All right, a void order. The cause of this would normally be no jurisdiction, no service, no due process. Voidable orders are going to be more like procedure errors, wrong calculation, misapplied law. They did some things the wrong way. They can be fixed. So void orders, what would be the remedy for that? That's going to be a motion to vacate as void, a collateral attack, okay? Then you have voidable orders. The remedy for that is going to be appeal or a motion to modify. Those are going to be the two roles for that. So a child support order is void or voidable if ground, no subject matter jurisdiction. What this means is the court or the agency had no legal authority to enter the order under the state law. They had no authority to put you on child support. Okay, let me give you an example of that. That's an intact family. All right. What that pretty much means is you were living with your wife or whatever, and all of a sudden you was placed on child support. They had no subject matter jurisdiction to do that because child support is triggered when there's like an abandonment, public assistance. If the agency jumped the gun and put you on child support where y'all were already intact, that's subject matter jurisdiction. You were never supposed to be on child support, ever. How can you be placed on child support if y'all are living together? So that is subject matter jurisdiction, and that is a void order. You can go back and attack that at any time, okay? So now you have personal jurisdiction, all right? The court never obtained power over the defendant. How does this take place? That's no service, defective service. They sent it to the wrong address or gave it to the wrong person. They had bad proof of service. It was false. Or service publication without due diligence. Now, you can get served different ways, but they have to really prove that they strive to serve you the correct way first. I mean, that's personal jurisdiction. That can be void, all right? So, no due process. The defendant was not giving a notice and opportunity to be heard, all right? So, how does this kind of take place? No notice of the proceeding, no hearing took place, no opportunity to contest at the hearing, no knowing waiver of rights. All right, you was never even there. I never had a court date. Y'all never even had a hearing. How can y'all put me on child support without a hearing? The order's void. Okay, so this does not mean that most child support orders are void. I don't want y'all to think that's what this means because it doesn't. All right, most are actually valid. Most people do actually owe child support. This only applies where the court or the agency never had jurisdiction or never gave you due process. But those are very rare cases, okay? The order isn't just wrong, it's legally nothing. All right, that's those cases. Not everybody has that situation, all right? So what I want to do is I want to get into some void order case law for y'all, all right? Yeah. Y'all know how I'm coming. I got the brain case law. That's how I'm moving. Let's get into this first case law. That's going to be USA versus Kramer, 225 F.3D 847 7th Circuit in the year 2000. Okay. So this is coming out of 7th Circuit Court of Appeals out of Oregon. All right. What is the background? A father was prosecuted under the Federal Child Support Recovery Act, CSRA, for failure to pay child support. Underlying state support order had been entered by default without personal jurisdiction over the father. Now look up this case. What happened? Kramer was criminally prosecuted for failing to pay child support under the federal CSRA. He argued that the underlying state child support order was void because the state never had personal jurisdiction over him. He was never properly served. The government argued he couldn't challenge the state order in federal criminal court. So, legal question. Can a defendant in a federal child support prosecution challenge the underlying state order as void for lack of personal jurisdiction? Outcome. The 7th Circuit Court held that the default child support order entered without personal jurisdiction is void and can be collaterally attacked, even in a federal criminal prosecution. The court said this long-going standing rule, both in federal and state jurisprudence, okay? A default judgment without personal jurisdiction is a nullity. They have to serve you properly. You have to have an opportunity to come to court and be heard, okay? Federal Appeal Court said default orders without personal jurisdiction are void, can be attacked collaterally, even years later, even in criminal court. This is a long-standing rule, not a new theory. This ain't new, y'all. This is way back in 2000, okay? UIFSA requires jurisdiction for recognition. No jurisdiction means no valid order. This applies to default orders where you were never properly served. All right. Kramer is a 7th Circuit case, federal appeals court. All right. A father was criminally prosecuted for not paying child support. He said the underlying order was void because I was never served. The court agreed. A default order without personal jurisdiction is a nullity, okay? And it can be attacked at any time. This is not my opinion. This is the Federal Court of Appeals, okay, family? All right, so let's get into the next case law. That's going to be U.S. versus Bigfoot 365 F.3D 859 10th Circuit in 2004. So again, that's U.S. versus BIG FORD. Okay, so this coming in the 10th Circuit Court of Appeals. That's out of Oregon. That's going to be the federal state that covers, I think it's Colorado. What is it? Kansas City, Oklahoma, Wyoming. There's some other ones too. It's like 2 or 3 other ones. So, what's the background of this case? A father was prosecuted under the Deadbeat Parent Punishment Act, DPPA, for failure to pay child support. Underlying Oklahoma support order was entered by default. Okay, what happened? Bigford was federally prosecuted for not paying support. He argued the underlying state order was void because the Oklahoma court lacks personal jurisdiction over him. The government said he couldn't raise the defense in federal court. Legal question. All right, what is it? Can a defendant challenge a default child support order on jurisdictional grounds in a federal prosecution? Outcome. The 10th Circuit Court held that a defendant can challenge a default child support order on the basis that the state court lacked personal jurisdiction under the Due Process Clause or state long-arm requirements. The court distinguished between jurisdictional defects, which makes an order void and attackable, and substantive errors, which are voidable but not attackable in federal court. All right? Okay? Y'all understand the difference? So, jurisdictional defects. Void can be attacked at any time. If your order is void, you can attack it 100 years later. It does not matter. All right? So, substantive error. That's when stuff get wrong. They got stuff inside of it. Name spelled wrong. It could be a number of things. These errors are voidable and they must be appealed through the state system, okay? Due process clause and state long-arm requirements both matter. Defendants bear burden to prove lack of jurisdiction. It's your job to go prove you were never served, okay? This is about whether the court ever had power over you. It just isn't about the child support court order. Like, this isn't is child support constitutional. Is it unconstitutional? Don't none of that matter. Y'all stop arguing this. That does not matter. Did the court have power over you? Did they do everything procedurally correct? Not if your straw man works. Not if your capital name is not really you, because it's in all caps, and it ain't you. It's your government name, and they're selling your CUSIP number. It don't none of that shit matter. I don't care if it's real or not. All that can be accurate. Don't none of that matter when you're talking about your child support order. None of that. I don't all that sovereign citizen shit. It don't work, bro. I've been there. I've done it. I've told the judge I'm here on special pensions. You ain't got. I done been there, family. I'm telling you what worked, what actually worked, what I learned that worked, that actually terminated my child support orders. I'm not here trying to tell y'all a golden ticket on how to get off child support. That ain't what I'm here for, okay, family? I'm trying to teach y'all something. So let's keep it pushing, man. Let's keep it pushing. All right, I'm gonna give y'all some more case law on these void orders because it's a big thing, man. I ain't gonna lie. Some of y'all do have void orders, and some of y'all can still attack them. Y'all have not waived y'all rights, and we're gonna get into that because, again, I would be remiss. And I'm trying to find a lane to see how long my videos should be. I don't know how long my podcast should be. As of right now, my video editor told me I had over 2 hours. He had to cut back on the last episode, and that hasn't come out yet. I'm going to try to drop every Wednesday, once a week, and bring y'all some information, bring y'all some real information. But it's the fact that it's like I don't want to give y'all bits and pieces. I could just skip over this, give y'all one case law topic, and maybe we will do that. Right now, I want y'all to understand that this has been around for a while. These case laws exist. You can work with inside the system and get relief. You do not have to try to work outside the system and do some special remedy thing that's not relevant to your situation. Okay, so let's get into this next case law. That's going to be U.S. versus Curley, Kerley. Okay, 416 F.3D 176 Second Circuit in the year 2005. Okay, so this came out the Circuit Court of Appeals. Again, this is federal, so it covers, I think, New York, Connecticut, Virginia. So, background. A child support order validity was challenged based on whether the issuing court followed all state procedural steps, okay? What happened? The defendant argued the support order was void because the hearing examiner didn't follow a state procedural requirement before entering the final order. He claimed this stripped the court of subject matter jurisdiction. Legal question. Does failure to follow a state procedural step render a child support order void for lack of subject matter jurisdiction? So what was the outcome? The Second Circuit Court held that 28 USC 1738B, validity for interstate enforcement, turns on subject matter jurisdiction and personal jurisdiction, but the court rejected arguments that the procedural error strips jurisdiction. The court distinguished between true jurisdictional defects, which make court's order truly void, and procedural mess ups, okay? Which makes order voidable, but don't void them. They're two different things, y'all. Void and voidable, okay? So 1738B requires subject matter jurisdiction and personal jurisdiction for a valid order. You need both. But procedural errors don't automatically void an order. There's a difference between jurisdictional defects and procedural defects, okay? Y'all understand that? Two different lanes. This protects you from frivolous, void claims, but support legitimate ones. All right. You got some people just saying anything to try to get off child support. Then you got some people that's really supposed to be off of it because it was a void order. Okay. The test: did the court have the power to act, not whether they acted perfectly? That's going to be the key question. It's not about if the court did everything correctly. They can do some things wrong. And we're going to get into how you can even waive your rights when they do wrong. Okay? Let's get into the key here. Curley was from the Second Circuit Court, all right? This makes a critical distinction. Just because the court made a procedural mistake doesn't make the order void. But if the court never had jurisdiction over you in the first place, never served you, never had authority, that's completely different. Now that's a void order, okay? All right? All right, so let's get into some of this void order statutory framework. Again, you got 28 USC 1738B, full faith and credit for child support orders, okay? What this does, this statute governs when child support orders must be recognized and enforced across state lines. An order is made consistently with this section only if the issuing order has these things, okay? A, subject matter jurisdiction. They gotta have it to put out an order, okay? B, personal jurisdiction over the party. They have to have personal jurisdiction over you to put out a child support order. And C, reasonable notice and opportunity to be heard was given. Orders that don't meet these requirements are not entitled to full faith and credit. All right? So, three requirements: subject matter jurisdiction, personal jurisdiction, due process. All right? Miss any of these, and the order isn't entitled to enforcement. Okay? This is a federal law. It's going to apply everywhere. Courts includes administrative agency. Same rules apply to them too. All right? If the agency lacked authority under state law, the order fails subject matter jurisdiction. All right? They have to have subject matter jurisdiction. This can never be waived. So again, 1738B, this tells us exactly when a child support order is valid to the T, all right? Three boxes: subject matter jurisdiction, personal jurisdiction, and due process. If you miss any of these boxes, the order isn't entitled to the recognition and enforcement. That's not a loophole, okay? You gotta understand that. That's not some loophole. That's just federal statute. That's how it works. All right, let's get into another one. I think I touched base on this one earlier. I might have been a little bit out of order. Again, I'm new to this. I'm not true to this. But it's going to be 42 USC 666. Yes, I remember talking about this because that number is crazy. But this is the due process requirement, okay? What this does is this statute authorizes states to use administrative processes to establish and enforce child support, but it's conditioned that authority on due process be compliant. All right. The statute says administrative processes shall be subject to due process safeguards, including requirements for notice, opportunity to contest the action, and an opportunity for an appeal. Default orders require a showing of process. Enforcement requires full compliance with all procedural due process requirements of the state. Okay. I'm kind of long-winded on that. I hope y'all caught that one, okay? But let's break down what due process is. I know y'all hear this all the time. Oh, I wasn't served due process. I wasn't given my due process. Do y'all even know what due process means? Do you? Do you really? So administrative authority is conditioned on due process. You know, y'all try, there's a difference between judicial and administrative law. That'll have to be a whole nother episode. I'm already adding on void to the termination episode, which it's only right. So default orders require proof of service. If you have a default order, they need to have served you and they need to have proof of it, okay? Enforcement requires full compliance with due process. No service, no hearing, no valid order under federal standards. All right. This is a federal requirement the state agency must follow. This is mandatory. This type of stuff, they have to do this to get their funding. Do they always do it? That's up to you to find out, okay? All right, so 42 USC 666, that is the number. I didn't make it up. Doesn't just give agency power, it conditions that power on due process. Notice, opportunity to contest, opportunity to appeal. Default orders are required for service of process. If they didn't serve you and you didn't appear, they didn't meet federal requirements. Okay. All right, so along this line, let's try to get into some defective services. Key out some state law examples, and we'll try to get on to, let me see here. Family, it's so much I built. It's like I had to put it together on a podcast, and at the end of the day, I guess, I mean, it's my podcast. We can make it as long as we need to, but it's like it's just so much I could dig in with y'all, and really so much case law, so much research I do for these videos. I do an overkill to the point where it's like, man, I may have to do a course or do some classes and share my screen with y'all. And man, it's so much. But so I want to get y'all, I want to show y'all, let's dig into defective services, what it actually means to not be properly served, or at least some state law examples. So we're going to start with California, all right? So this is the county of San Diego versus Gorham, Gorham. That's going to be 186 cal dot APP.41215 in the year 2012. So I think that's going to be the Court of Appeals. All right. And this is in California. So what was the background in this case? A child support default judgment was entered against the father. Evidence later showed he was incarcerated at the time he was allegedly personally served, meaning service was false. What happened? The father showed that the proof of service was false. He was in jail when the process server claimed that he had personally served him. The county had obtained a default judgment based on false service. Years later, he moved to vacate the judgment as void. What is the legal question, family? Is a default judgment void when obtained through false proof of service? All right, family, my bad. I knocked over my water. Okay. So, what was the outcome? Let's get into it. Da-da-da-da. All right. The court held that default judgment was void, not voidable, for lack of personal jurisdiction because Gorham was never actually served. Okay. The court never obtained jurisdiction over him. All right. A void judgment can be set aside at any time, even years later. Even after statutory deadlines have passed, it doesn't matter. If it's void, it's void. Okay, family? All right. So, false proof of service equals no jurisdiction equals void judgment. Void judgments can be attacked at any time. There is no deadline. Extrinsic evidence like jail records, whatever you can prove that you weren't served, it's going to be a win. Okay. Court said this violates fundamental due process. This applies when you can prove the service actually never happened. You need proof. So, again, Gorham, he was jailed when they claimed that they served him. Years later, he proved it. The California court said the judgment was void, not voidable. Void. Never served means no jurisdiction. No jurisdiction means no judgment, nothing. The judgment is absolutely nothing. It can be attacked at any given time. Okay, family? So, let's get into another case law. That's going to be Deal versus, I think it's Berquist Construction Company. 24 Cal APP. That's going to be the California Court of Appeals. 1426 is going to be in 1994, family. All right. It's out of California Court of Appeals. What's the background? All right. A foundational California case establishing when default judgments are void for defective services. What happened? The defendant was allegedly served with summons and complaint, and a default judgment was entered. The defendant later challenged the service as defective. Legal question: when is a default judgment void for lack of proper service? Okay. Outcome: the court established the rule compliance with statutory procedures for service of process is essential to establish personal jurisdiction. Thus, a default judgment entered against a defender who was not served with a summons in the manner prescribed by the statute is void. Okay. All right. The court also clarified that actual notice does not cure defective service. Statutory compliance is required. You need to be served properly. You can't just know about the court. You need to be served properly. Okay. So, compliance with service statutory is essential to personal jurisdiction. Default judgment without proper service is void. Actual notice does not cure defective service. This is critical, family. Okay. Even if you got the word, that doesn't mean it gives the court jurisdiction. You need to be properly served. Void judgments, listen, these can be attacked at any time. I don't care how much time has passed. Okay, so deal. This is a California case that everyone cites. A lot of people like to cite this. If you weren't served according to the statute, the court never had jurisdiction. The judgment is void. And here is what is critical: the notice does not cure it. Even if you knew about the case, if they didn't serve you right, the judgment is void, family. Okay, so let's get into some practical application. Let's see if you actually have a void order. All right, I want you to ask yourself these questions. One, were you ever personally served with the summons, complaint, and or petition? Two, if substitute service was used, was it done correctly? Was it left with the proper person? Was it mailed? Etc. All right. Three, if service by publication, did they try other methods first with reasonable diligence? They have to really try to find you. Did you make a general appearance? Did you file anything or show it without objecting to the jurisdiction? Did you show up and start arguing about money? Did you show up and start arguing about I don't get to see my kids? Or 5, did the agency have statutory authority to initiate the case? Were you separated? Was somebody on assistant? Did somebody file for government assistance, food stamps? What was it? Number 6, were you given notice and opportunity to be heard before the order was entered? Did you get to say what you needed to say? Did you get to argue what you need to argue? Did they even have a hearing? A lot of these cases don't even have hearings at all, which is crazy to me. I ain't have a hearing for one of mine. It's crazy because we were living together. So if your order might be void, I want you to go and do this. I want you to get your case file, request all the documents, including proof of service. This is going to be at the courthouse. Don't go to the DOR office. Don't go to them people that they go to the courthouse. All right. If it's court ordered, go to the courthouse. 2, analyze the proof of service for defects. This is going to be wrong address if they say the wrong person received it, if the dates don't really align, okay? 3, gather extrinsic evidence if needed. Were you incarcerated? Were you living somewhere else? Can you prove this, okay? 4, check if you made a general appearances. This can waive jurisdictional objection. If you just showed up, this may waive your right to argue that the order is void, all right? 5, determine if defects appear on the face of the records or requires outside evidence. 6, file appropriate motion. Motion to vacate void judgment. If you're in California, I think it's under state equivalent of CCP 473D. All right, but warning, claiming you have a void order when it's really not is going to hurt your credibility with the judge. They're going to think you're crazy. They're going to think you don't know what you're talking about, all right? This is a narrow dock for a specific situation. This is not some magic escape trick, all right? Get your facts before you file anything. I need y'all to do that, family. All right. So if any of you are wondering why I didn't have any Supreme Court rulings on this, like you say Supreme the big dog, why didn't you cite any Supreme Court cases saying that child support orders are void for lack of jurisdiction? Because there was no need to. There are building blocks when you get into the U.S. Supreme Court, and there are precedents that set the standard for civil arguments, which that is what child support is. It is a civil state issue. So let's get into the framework and the 4 pillars of why you're not going to see these child support orders are void for lack of jurisdiction in the U.S. Supreme Court, okay? They've already laid controlling legal principles that make orders void, all right? They already set the foundation. So 1, it's going to be, I don't know how to pronounce these people's name to be on the screen. I want it to get in the spelling for the people that may be riding and listening. I ain't even that big yet. When I blow up, maybe we'll figure it out. I'll pay a grammar coach or something. I know how to pronounce everyone's name. But until then, you have to watch me on YouTube to get the actual citations to pop up. So this is going to be, I think it's Pena versus Neff. That's 1878. The citation is 95 U.S. 714. The background of this case, Neff owned land in Oregon. Mitchell sued Neff for unpaid legal fees. Neff was out of state and was never personally served. The Oregon court published notice in a newspaper, entered a default judgment, and sold Neff land to Pena. Neff later sued to get his land back. So what happened, all right? Neff argued the original judgment was void because he was never served and the court had no jurisdiction over him. The case went all the way to the U.S. Supreme Court. The legal question, can a court enter a binding judgment against a person who was never personally served and never appeared? Outcome, the Supreme Court ruled the original judgment was void. A court has no power to bind a person with a judgment unless it has personal jurisdiction. And personal jurisdiction requires valid service of process. No service, no jurisdiction, which equals a void order. Do y'all hear me? This is the Supreme Court. They've already set foundations for this. This is the foundation. 1878, almost 150 years ago. The court explicitly said no service equals no jurisdiction equals judgment is void. This wasn't about whether the debt was real. They don't care if the debt was real. It was about whether the court actually had power. Every void order case since then traces back to this case. Okay, look it up. The Supreme Court ruled 1878, Pena versus Neff. They ruled that a court has no power over you unless you are properly served. That's not new law, family. This is 150 years old, okay? That's the foundation of the American civil procedure. If you weren't served, the court didn't have jurisdiction. If the court didn't have jurisdiction, the order is wrong. It's legally non-existent. Period. Ain't no magic to that. Ain't no trick to that. That is case law from 150 years ago. Come on, man. Let's get into another case law. We'll call it Moline versus Central Hanover Bank. Moline. All right, so this is in 1950, 339 U.S. 306, U.S. Supreme Court. All right, so let's get into the background of this, okay? Central Hanover Bank managed trust funds for many beneficiaries. New York law allowed the bank to publish notice in a local newspaper to cut off beneficiaries' right to object to the accounting, okay? Milan argued this publication notice was constitutionally insufficient, okay? What happened? The bank published a notice in a local newspaper that almost none of the beneficiaries would ever even see. The beneficiaries' rights were being terminated without any real notice. Milan challenged whether this satisfied due process. Legal question. What kind of notice does the Constitution require before a court can bind someone to a judgment? What was the outcome? The Supreme Court held that due process requires notice reasonably calculated under all the circumstances to apprise interested parties of the pendency of the action and afford them an opportunity to present their objections, okay? Publication notice is only acceptable when the person address is truly unknown. If you have their address, you have to mail it to them. You have to give them a chance to be heard, okay? So, due process means real notice, not just technical compliance. Notice must be reasonably calculated to actually reach you. Publication notice is absolute last resort, only when the address is unknown. If they had your address and didn't mail you, notice fails. Failed notice equals failed due process, failed jurisdiction. Y'all getting it? Is it making sense to y'all, okay? All right, this is a Supreme Court case on notice. This is the Supreme Court case, okay? The court said that the process requires notice that reasonably calculated to actually reach you. They have to reach you. They have to put in all the work to reach you, okay? They got your address, they got to mail you. There's no reasonable notice. There is a due process violation. Without due process, no jurisdiction, y'all. Come on, man. I'm taking y'all to school here, man. I need to put a GoFundMe up much. I'm teaching y'all, man. They don't teach y'all this in law school, probably. I don't know. Come on, man. All right. Case number 3. All right. This is a big one. This is the golden one. This is the one that aligns with child support. No, it ain't go say child support because it's already building blocks. Okay. So case number 3. All right. I don't know how to pronounce this person's name. Peralta versus Heights Medical Center. This is in 1988. The citation is going to be 485 US 80 US Supreme Court. This case is gold, all right? Let's get into the background, all right? Heights Medical Center sued Peralta for an unpaid hospital bill. They claimed to have personally served him. A default judgment was entered. Peralta property was sold to satisfy this judgment. What happened? Peralta later proved he was never served. The proof of service was false. He moved to vacate the judgment. The hospital argued that even if service was defective, Peralta actually owed the money. So the result would have been the same anyway. So what is the legal question? Can a default judgment stand if service was defective, but defendant actually owed the money? What was the outcome? The Supreme Court ruled unanimously. Okay, every last one of the judges on the panel ruled that the order must be vacated. This judgment must be vacated. It does not matter whether the debt was legitimate. It does not matter whether the result would have been the same regardless, okay? If he would have showed, if he would have appeared, that's another story. All that matters is defective service equals due process violations equals a void judgment, period. All right, family. So this is literally the kill shot. Even if you owed the money, the judgment is still void. Supreme Court rejected this no harm, no foul argument. Defective service is a constitutional violation, not just a technicality, okay? The result does not matter if the process was unconstitutional. This applies directly to child support. Owing support does not validate a void order, family. This is the Supreme Court telling y'all that this is not me. This is the Supreme Court case that people need to hear. The hospital said, so what if we didn't serve him right? He still owed the money. If you still owed the money, then the judgment still should be entered regardless. No. If the service isn't done correctly, it is unconstitutional and it must be vacated. This applies to child support. Ongoing support doesn't make a void order valid. Just because you owe the child support, that don't mean the order's valid. You can have a void order. And the Supreme Court says so, okay? So let's get into this fourth case. International Shoe Company versus Washington, 326 US 310, 1945. Worldwide Volkswagen Corporation versus Woodson, 444 US 286, 1980. All right, so let's get into the doctrine of this. This case established that personal jurisdiction is a constitutional prerequisite to any binding court order, okay? A court must have a minimum context with the defendant such that exercising jurisdiction doesn't offend traditional notions of fair play and substantial justice, okay? Let's get into it. Jurisdiction isn't a procedural rule. It's a constitutional. It's constitutional. It's not a procedural rule. This is a constitutional. Do you hear me? No minimum context equals no jurisdiction equals a void order. This protects people from being sued in states where they have no commitment, no ties, no connections, okay? Child support agencies still have to satisfy constitutional jurisdictional requirements. Mandatory, y'all. Talk to me. All right. So international shoe in this worldwide Volkswagen, this established that jurisdiction is constitutional. A court can't just reach out and grab you and put you on child support. There has to be a minimum context. There has to be fair play and substantial justice. Child support agencies don't get to skip those requirements just because they're child support. All right. There is no Supreme Court that says the specific child support order is void because there doesn't need to be. The Supreme Court already ruled on this repeatedly that any civil judgment entered without jurisdiction or due process is unconstitutional and void. Child support orders are civil judgments. Do you understand me, family? That's why the federal courts and state courts are allowed to void support orders. Even now, today, to this very day, you can get your child support order void, okay? So, all right, this isn't something I made up. This isn't a TikTok theory. This is 150 years of constitutional law, all right? I think it's Pena 1878, Milan in 1950, Peralta in 1988, okay? The Supreme Court has been saying the same thing for generations. No service, no jurisdiction, no void judgment. Do you hear me, family? All right. So the Peralta, all right, the Supreme Court already ruled unanimously that even if you actually owe money, a judgment entered without proper service is still unconstitutional and must be vacated. All right. Okay. 1988. The debt being real does not make the process constitutional, okay? This isn't a loophole, family. This is the foundation of American civil procedure. Every lawyer is supposed to learn this in the first year of law school. All right. Most people aren't supposed to know this because they're not lawyers, respectfully. Come on, man. Y'all out here giving people advice on TikTok, man. Come on, man. Anybody that's giving advice on TikTok have not probably studied law school. Me either, but I've been studying this for years. We're bringing it to a closing, but I got to go over one more thing, and I hate to do it. I hate to do it to y'all family. I really do. But I have to get into this, okay? This is how you can actually waive jurisdiction and service defects. Okay. So again, let me try to get into this. All right. So personal jurisdiction, I need y'all to know this, and service defects, they are waivable. Okay. Subject matter jurisdiction, you can never waive this ever. It doesn't matter. They have to have subject matter jurisdiction. It is mandatory. So let's get into this. Controlling Supreme Court law. All right. So this is going to be Insurance Court of Ireland versus Campagne des Boutiques de Jouin. That is definitely French or something. All right. 456 US 694. This is in 1982, family. And of course, the Supreme Court, the big dial, is getting to the background. All right. A dispute arose over insurance coverage for a mining operation in Ghana. I believe that's what that says. The insurance companies refused to comply with discovery orders, claiming the court lacked personal jurisdiction over them. What happened? The district court imposed sanction for discovery abuse by deeming the jurisdictional facts established. The insurance companies appealed, arguing that personal jurisdiction is a constitutional requirement that cannot be established through sanctions. Okay, legal question. Is personal jurisdiction a constitutional requirement that cannot be waived or forfeited? Or is it a personal right that can be lost through your conduct? I don't tell you about this part, okay? So, what was the outcome, family? The Supreme Court ruled that personal jurisdiction is a waivable right, unlike subject matter jurisdiction, which goes to the court's fundamental power. Personal jurisdiction exists to protect individuals' liberty interests, and like other individual rights, it can be waived and or forfeited. Get hip, family, okay? So the requirements of personal jurisdiction represents first of all key holdings, okay? The requirement of personal jurisdiction represents first of all an individual right. It represents restriction on judicial power, not as a matter of sovereignty, but as a matter of individual liberty. Thus, the requirement is a waivable right. You can waive these rights. You can give them up. Why this destroys 90% of these TikTok void advice videos, okay? Even if service was defective, even if notice violated due process, even if all these case laws I Mr. Pena, Malone, Peralta would otherwise help you, you lose the argument forever if you don't raise it first. That has to be one of the first things you argue when you in court arguing, that they never had personal jurisdiction over you. Okay? This is the part people ain't telling y'all about. This is the Supreme Court case on jurisdiction waiver, okay? Personal jurisdiction protects you, so you can give it up, all right? Subject matter jurisdiction protects the court's power. You can't waive that, all right? You can't waive whether the court ever had the right to even hear this case from the jump street. You hear me, family? Okay? Participation equals waiver. Even if you didn't know you were waiving anything, if you come to court arguing other stuff, it don't matter if they never personally served you. You waived that right to be personally served by showing up arguing other topics, family. Okay? So this explains why people who find out years later about service defects often can't do anything. Sometimes it really is too late. Sometimes it's too late. A lot of times it's too late. A lot of y'all cannot void y'all orders, but that don't mean you can't terminate ongoing support. That don't mean you can't find a better situation to be in within the system. Come on, y'all. The order might have been void on day one, but it's bulletproof on day 3,000. You hear me? Come on, man. So, man, this is what nobody's telling y'all about these service defects and jurisdiction challenges. You can actually waive them. The Supreme Court ruled in Insurance Corp of Ireland versus Capain des Bontiques that personal jurisdiction is a waivable right. That means if you show up to court and start arguing about the amount, if you file paperwork disputing the calculation without first objecting to the jurisdiction or the service, you just gave the court power that you're claiming they never had. How they never had it, but you gave it to them. You done showed up arguing everything under the moon besides jurisdiction. Come on, family. Come on, y'all. Let's get into the mechanism of this waiver. How courts analyze whether you waive jurisdictional defects, okay? Let's get into how the courts decide this, all right? You waive jurisdictional and service defects when you appear in court and argue the merits. That's amount, custody, arrears, okay? When you file a response without raising jurisdiction service defects, okay? If you don't do that as your first defense, then you might have waived your right, okay? If you enter into a stipulation or contest to the order, all right? If you enter a stipulation or you're contesting the order, if you're arguing them, then you might have already given up jurisdiction, okay? Request modification with knowledge of the court's authority. You might have just waived your jurisdictional argument, okay? Ask the court for any affirmative relief. If you're dependent on the court to get off child support, you're dependent on them to be able to put you on it, okay? Participate in the hearings without objecting. Negotiate with the agency on the record. Make payments through the state. Acknowledge the order's validity in any type of filings. Then you may have already waived your rights to void this order, okay? The first filing rules, okay? This is in almost all jurisdiction, okay? Jurisdiction and service objection must be raised in your first response of pleading or they are waived forever. If you don't make that your first argument, they gone. The rules come from state civil procedure rules, federal rules of civil procedures 12H1, uniform case law across all 50 states, okay? So how do you end up waiving this without even knowing it, all right? This is where real parents get destroyed. Again, they show up to the hearing and argue about the support amount. They file a response disputing the calculations, okay? They ask for a payment plan. They request for modification. They sign a consent order. They call the agency and try to work something out. They start paying through the SDU. They file pro se motions without jurisdictional objection. Y'all just giving away this and probably don't even know it. All that is submission to the jurisdiction. This is how most parents destroy their own case without even knowing it. Y'all show up to court and y'all start arguing about the amount. Y'all filing for everything under the moon except for the objection to the jurisdiction, except the due process claims. Y'all arguing about everything else besides that, okay? Let's get into the interaction with your Supreme Court of the United States doctrine, all right? We already know about the Pena, Mullen, the Peralta establishment, those Supreme Court case where no service equals no jurisdiction. That's a void order. Notice must be constitutionally adequate, even if the debt is real. Judgment entered without service is void. Okay, we got all those rights. But what Insurance Corp of Ireland adds on to that is those rights can be waived. Defective service does not automatically mean permanent voidness, okay? And participation can cure jurisdictional defects going forward. Just because it was messed up now, that don't mean we can't fix it and have it pushing forward, okay? So, I know it, y'all. I know this ain't what y'all want to hear. The void judgment can become immune to attack if you waive jurisdictional defects. I'm sorry, y'all. That's just the truth. I mean, I know y'all may feel like that's unfair, but that's the law. Yeah, your order was void. It was voidable. They done messed up your whole thing 10, 20 years ago. I'm sorry you didn't find that out 10, 20 years ago, but that's where we at, okay? All right, so listen, I can't stress it enough. These service defects do not give you a lifetime kill switch, all right? It gives you a one-time procedural defense. If you don't use it correctly, you're gonna lose it forever, all right? That's all it is. You get one time to fix it, don't use it, it's a wrap. So how do you preserve these jurisdictional objections? Parents, listen, it's for the parents who haven't yet appeared in court. You already appeared in court, that's ain't for you, so that's what I want you to do. If you haven't appeared in court or you haven't participated, all right? Raise jurisdiction and service objection in your first filing. Your very first filing, if you was not properly served, you need to be filing that first. Then this is when you file a special appearance, family. All right, where your state actually is going to allow it. This is like y'all hear all that special appearance online, family. If you already been to court and argue other stuff, they gonna look at you crazy. Special appearance is not for you. This is for parents who have never been or participated. Okay, I want you to object before arguing anything else. Object to the jurisdiction. Don't get in there arguing the amount. Don't start talking about custody. Object to the jurisdiction. Don't talk about how much you already do for your child. None of that. Okay. Put it in writing. Verbal objection often really don't count. You gotta literally file your objection. File it. File the motion. You don't know how to do it, look it up or reach out. I do consultations, okay? Preserve the objection even if you also address the merits. So let's say you get into where you almost about to lose custody or something like that. You still gotta argue objection. You still gotta object to the jurisdiction. I'm not telling you not to defend yourself against your custody rights or whatever you need to do, but you need to argue that jurisdiction a lot sooner than later, okay? All right, family. All right, family. This is what I don't want you to do if you haven't showed up already, okay? I don't want you to show up and argue about the amount first. Don't go to court arguing about the amount first. We need to talk about the jurisdiction, okay? Don't file a response about custody without raising jurisdictional issues, okay? Not telling you not to file custody, just don't file it without raising those jurisdiction issues as well, okay? Don't enter any agreement without preserving that objection. You got to preserve your right to object, okay? Do not make payments through the system before objecting to the jurisdiction, okay? Do not wait to see how it goes before raising it. Go ahead and raise it. Don't wait to come to court and then you plan on doing it. File the motion. The minute you realize you haven't been properly served and you haven't shown up or done anything, file that objection, okay? All right? I think that's pretty much it, family. Make sure we don't win over everything. This is JL Casey. This is Family Court Unfiltered. This is episode 2, the truth about terminating child support, what the internet won't tell you. All right, that's going to be the title of this episode. Man, I want y'all to lock in. It's 2026. We got to get real. I really want y'all to get serious about this, okay? So I want y'all to have some takeaways from this. I want y'all to understand that termination, yes, it is real. I promise you, family, I've terminated all 3 of my child support cases. I've done it 3 separate times. I had 0 ongoing child support case, all right? But it wasn't some magic word, and it's not going to be for everyone, all right? It's just not, all right? Before you file anything, you need to understand what termination actually does, whether you qualify, and what actually happened to your arrears after you terminate your child support. All right. The parents who win are the ones who understand what they're actually asking for. You can't go in there filing motion asking for the wrong thing. All right. And you got to be doing it at the right time. You got to line everything up. There's a right time to file and there's a right type of motion to file. You got to align them both up. So, all right, family. So in closing, if this helped you understand family court and how it actually works, please save this episode and share it with someone who may need it. If you're dealing with a case and you need very specific and strategic help, please, that's what my consultant is for. ChildSupportVictory.com. Till next time, stay strategic, family. Strategize. Get off that TikTok. Y'all stop that. Don't get jammed up. Stay blessed.